Namaste students. I am Hans Kumar Sharma, Assistant Professor, Faculty of Law and Governance, Jayoti Vidyapeeth Women's University. Today's our topic is Grevious hurt, which is a very important session of the semester. Presently, a large share of criminal cases, more specifically in the courts of Judicial Magistrate First Class in India, is hurt cases. For example, offences culpable under Section 323, 324, 326 of Indian Penal Code 1860. There is no criminal code without these cases. Hurt is known as influence, damage to prompt, torment to, harm, debilitate, harm, wound, cripple, weaken, harm. In different words, it implies be unfavorable to. In the event that delineation utilizes wounds as an action word, it doesn't separate between the damage of simple nature or grievous nature. The designers thought that it was hard to draw a line between those substantial damages which are serious in nature and those which are slight. They say that to draw such a line with great precision was totally impossible. Therefore, specific sorts of hurt were assigned as grievous. Hurt may be described as the bodily pain that is resulting from real contact with the frame by an aggravated assault. There is no radical difference between assault and harm. Section 319 of the Indian Penal Code 1860 defines hurt as whoever reasons bodily pain, disorder, or disease to any man or woman is said to have caused harm. The section does not outline the offense of inflicting harm. It defines best the time period hurt and does not describe the situations underneath which it can be brought on. To constitute any one or more of essential of simple hurt must be present bodily pain, infirmity to another, and disease. According to section 319 of the Indian Penal Code, whoever cause bodily ache, disorder, or disease to an individual is said to cause hurt. The expression physical pain means that the pain must be physical instead of any mental pain. So mentally or emotionally hurting anyone will no longer be harm inside the meaning of section 319. However, to be covered under this section, it isn't always important that any visible injury should be participated at the sufferer. All that the section contemplates is the inflicting of bodily pain. The diploma or severity of the ache or pain isn't a fabric element to decide whether section 319 will apply or not. The duration of ache or pain is immaterial. Pulling a girl with her hair would amount to hurt. We can understand this through a case law, which is in State versus Ramesh Das on 22 May 2015. In this case, in a hospital, passing through the corridor and the new surgical block location, an unknown public individual came from the front and attacked the woman. The individual pulled her hair and threw her to the ground. He hit her on her head together with his hand. Accused was convicted for the offence under section 341 and 323 of the IPC and acquitted for the offence under section 354 of the IPC. Infirmity to another. Infirmity denotes the bad state of frame of mind and a state of transient intellectual impairment or hesitaria or terror wound constitute disease inside the meaning of this expression inside the section. It is an incapability of an organ to carry out its everyday function, whether temporarily or completely. It may be delivered through the administration of a toxic or poisonous substance, or by means of taking alcohol administered by way of any other person. We have another case regarding this. Jasnamal Jamtamal versus Brahmanand, AIR 1944. In this situation, the respondent has been evicted with the aid of the honor. He attempts to get revenge while evicting others from that constricting too. Respondent later confirmed with his spouse with a pistol in his hand. What is disease? Communication of element or disease from the individual to another through the way of touch would constitute hurt. But the idea of unclear with respect to the transmission of sexual sickness from an individual to every other. For instance, a prostitute who had intercourse with a person and thereby communicated syphilis chains into held in charge under section 269 of the IPC for spreading infection and not for inflicting hurt due to the fact that the interval between the act and sickness turned into too far away to attack section 319 of the IPC. In Raka versus Emperor, the accused was a prostitute and she inflicted syphilis to her customers. It was held that accused, the prostitute, was liable under section 269 of IPC, negligent act, likely to spread infection of any disease dangerous to the life of another person. Intention or knowledge is an important aspect of causing hurt to an individual. A person who intentionally sets out to purpose a shock to somebody with a weak coronary heart and succeeds in doing so, he is said to have caused hurt. Any bodily act due to management of capsules can be protected under harm. Whilst the harm isn't always served and there is no purpose to cause death or grievous hurt, the accused could be guilty or inflicting harm most effective despite the fact that death is caused. In Marana Godan versus R, the accused demanded money from the deceased, which the latter on him. The deceased promised to pay later. Thereafter, the accused kicked him at the abdomen and the deceased collapsed and died. The accused chased into hell, guilty of causing hurt, as it couldn't be stated that the Meenthoff knew that kicking at the abdomen become in all likelihood to hazard existence. Section 321 of the IPC defines voluntarily causing harm as whoever does any act with the intention of thereby causing harm to any person or with the expertise that is likely thereby to reason harm to an individual and does hereby motive harm to any person is stated voluntarily to motive hurt. What constitutes a selected offense relies upon the character of the act achieved, but additionally upon the character of aim or know how with which it's far carried out. Section 319 define the nature of the actus reus, which might constitute the offense of voluntarily causing harm punishable under Section 323. And Section 321 describes the means mens rea necessary to represent the offense. Google and information need to be proved. The person in reality hurt once. No, now, not always be the person who becomes intended to be hurt. Section 321 describes the situations that outrange the act with factors of criminal activity making it an offense. The instances are doing of an act to any person with the goal or know how of causing harm. Now, what is grievous hurt? The draftsman of IBC found it tough to draw a line among those physical hurts which can be severe and people who are moderate. However, they special certain types of hurts as grievous hurt. The fall on the kinds of hurt only are termed as grievous are emasculation, permanent injury to eyesight or either of the eye, permanent deafness or injury to either of the eye, privation of any member or joint like loss of limb, impairing of limb, permanent disfiguration of the head or face, fracture or dislocation of a bone or tooth, any hurt which risks life or which causes the victim to be during the time of 20 days in severe bodily pain or unable to follow his ordinary pursuits. Now, what is emasculation? The first type of grievous hurt is depriving a person of his virility. This causes comfort to man and was inserted to counteract the practice commonplace in India for women to squeeze man's testicles at the slightest provocation. Emasculation can be resulting from causing such harm to the scrotum of a person as has the effect of rendering him impotent. The impotency prompted out to be permanent and no longer simply temporary and curable. Injury of eyesight. Some other injury of identical gravity is the permanent deprivation of the sight of either eye or both the eyesight. Such harm has to have the effect of permanently depriving the injured of the uses of one of both of his eyes. The test of gravity is the Gravity is the permanency of the harm because it deprives a person of the uses of his sight and additionally disfigures him. Inflicting deafness. The everlasting deprivation of hearing of both ears is less serious than the above mentioned harm, above discussed harm, as it does no longer disfigure a person. However, handist deprives him of using his ear, but it is damage depriving someone of his sense of listening to. The deafness has to be permanent to attack this provision. Such harm may be resulting from blow given on head, ear, or the one's elements of the head which speak with an injured auditory or nerves, or with the act of thrusting a stick into the ear or placing into ear a substance which reasons deafness. For the loss of limb, everlasting deprivation of any member of joint is other grievous hurt, whereby a person is rendered much less able to guard himself or to harass his adversary. Member method, not anything extra than an organ or a limb. Joint refers to an area where two or more bones or muscle must be part of. The permanent deprivation needs to involve such damage to them as makes them permanently stiff, so that they are not able to perform to everyday function assigned to the human body structure. Further impairing of a limb, the deprivation of a person to the use of member or joint includes lifelong crippling and makes a person defenseless and depressing. The provision speaks of destruction or permanent impairing of the parts, which might encompass no longer only overall, however, additionally, a particular use of the limb or joint. Any permanent decrease of their utility would constitute grievous hurt. Everlasting disfiguration of the pinnacle of face. Disfigure means to do a person a few outside hurts which detract from his private look but does not to weaken him. Branding a lady's cheek with red warm iron, it leaves permanent scars. On to disfiguration occurred at the base of the nostrils of a woman due to a sharp weapon has been held to be everlasting disfiguration, meant despite the fact that the inner wall become intact. Further, fracture or dislocation of the bone or teeth. It's far every other species of grievous harm, which may additionally or may not be attended with the everlasting disability. A fractured or dislocated bone may be set or rejoined, but on account of the extreme suffering to which it gives upward thrust, the harm is named as grievous. The number one means of the word fracture is breaking through it isn't always essential in case of fracture of the cranium bone that it should be divided into separate parts due to the fact it may consist simply of a crack, but if it is a crack, it must be crack which extends from the outer floor of a skull to the inner surface. There may be spoil with the act of cutting or splintering of the bone, or there is a break or gap in it, would add up to a crack inside 2. Importance of clause 7 of section 320. What must be seen is whether the cords during the bone sign will damage, report just a shallow, or do they impact a break in them. Dislocation implies this losing being applied to a bone expelled from its typical associations with a neighboring bone. A bone moved out of its attachment or put out of its joint is a disjoint bone. And further, any hurt which risks life or which causes the victim to be during the time of days in severe bodily pain or unable to follow his ordinary pursuits. Uh, it's a dangerous hurt, we can say. So, it is sufficient for today's lecture, and as I told you before earlier, and starting of the lecture, this session, that this is the very important chapter of the Indian Penal Code, and we need to understand it very clearly. So, uh, I will refer you the Direct of the Indian Penal Code to study, and please find out some cases regarding the hurt and grievous hurt. And this is the task for today for all of you. Uh, Now, thanks for watching. Namaskar.